Hello, and welcome to Crime and Court. My name is Heather, and this is episode 25 of the Canton Cover-Up case that I'm doing a deep dive on. This is Karen Read versus the Commonwealth of, the Commonwealth of Massachusetts versus Karen Read. And she, as many of you probably already know, she's on trial for potentially unaliving her Boston police officer boyfriend, John O'Keefe, in front of another Boston police officer's house. It's very sketchy, and we all know, if you're following along with me, we all know that Karen Read is factually innocent based on the evidence, the court documents that we've been looking through, everything. So I wanted to kind of do, for this episode, and we're coming up on trial, so first of all, I do want to give you an update on the juror selection process, and then we're going to look at a little bit of the misinformation and the media and how the media has been portraying this case. I'm not going to get into a ton of it, but I just thought, it's important to note that it is part of the story as well. So before we get started, please hit the like button. Don't forget to subscribe. Make sure the bell's on so you get notifications for my videos. I'm doing a deep dive into the Canton Cover-Up. I will be covering it when it goes to trial. I'm going to try to do daily, just daily recaps. We're not going to watch the whole day, but I'll do like a recap of each day and give you the main points. I think that's the way I'm gonna do it going forward. So I'm gonna make sure that you guys are staying up to date in the case, even if you don't have time to watch it. I'm gonna watch it for you guys. So that is my sacrifice. I love watching trials. It's really not a sacrifice. All right, so we are going to, although it's just atrocious that this case is even going to trial with all the evidence that exculpates Karen Read, but we'll get to we've already been through all of it, but we can get to that in more detail in a bit. But here, so this video you're seeing right in front of you, we're gonna talk about juror selection in 1 second, but I just want to point out this right here is John, and this is Karen. This was the night of the incident. They were very lovey-dovey and affectionate with one another at the bar. I believe this is from Waterfall Bar Grill, or it might be because the Waterfall Bar and Grill, I don't think we ever saw any of the videos from there. I think it was just the first place they were at. Can't remember now, but as we can see, they're very affectionate. In this video, they're loving, and it doesn't seem like there's a reason why she would just all of a sudden go crazy and strike him dead. So yeah, we've talked about this video before and images of them cuddling up to one another, so I just wanted to make sure that that was pointed out too in this, because they did not seem to be fighting or anything of that nature. All right, so let's begin. This is from NBC 10 Boston. We're going to watch a little clip about jury selection. Jury selection is come to a close for this week. However, we're going to go into next week and continue jury selection, because on Thursday, I can't remember now, I think someone backed out, and then they got two more on Thursday, and then they're not doing any kind of jury selection today, which is Friday. They don't have juries in the courthouse on Fridays, so they're not doing jury selection either. So that would be meaning that we have to continue jury selection. We have, I think, 4 more seats that they need. So here, I'll let them tell you, because they're probably more accurate.
The first week of jury selection has come to an end, but there are still empty jury seats in the jury box. Good evening, I'm Glenn Jones, and this is Canton Confidential, the Karen Read murder trial. We have a lot to get to tonight, from one juror dropping out to potential DNA evidence found on the back of Read's SUV. We have 2 experts in studio with us tonight.
That's nothing new. The DNA that they're just found, no, they didn't just find it. It's the hair that they're claiming is John's which even if it is, who cares, because he has been in that car before and he's around Karen all the time. But they're saying that they found a hair that they claim is John's, and they're waiting for the DNA. It could very well be that they planted it themselves too. So who knows, and why do we care about this stupid hair? But the testing never got back to Adam Lally, prosecutor Adam Lally, until just now. And trial started the 16th, technically. Jury selection did. So the defense has been fighting to keep this evidence out, obviously, because now they have to go through it and find an expert to argue it. So it's a whole thing.
Right, to offer analysis and perspective. But let's begin with a quick recap. Karen Reed is accused of hitting her Boston police officer boyfriend with her SUV and leaving him for dead in the snow back in 2022. The body of Officer John O'Keefe was found the next morning outside the Canton home of a fellow Boston police officer, where the couple had been invited to attend a party following a night of bar hopping. Reed is now on trial for second-degree murder, but her defense team claims she's being framed by law enforcement. Now the trial is underway. Jury selection began Tuesday. Here's where things stand tonight. 12 jurors have been seated. 2 were selected today, and 1 previously selected juror dropped out. More on that a little bit later, but right now the prosecution and defense have just 4 more seats to fill for alternates. In the meantime, new documents filed in court today. They could lead to new DNA evidence in the case. NBC 10's Kirsten Glavin has been reading through that paperwork. She joins us now to give us an update on what the court filings are and how jury selection is going. Kirsten.
Yeah, Glenn, all of this is a bit of an arduous process, but it is crucial to get it right. Today, we did see a much smaller jury pool than what we've seen over the past few days, with almost all of those potential jurors saying they were familiar with this case already.
Commonwealth versus Karen Reed, 12-22-117.
Day 3 of jury selection for the Karen Reed murder trial coming up short. 12 jurors officially seated, with 4 more needed before opening statements can begin.
Good morning, Ms. Reed.
Judge Beverly Cannoni asking a jury pool of 52 if they'd heard of the case. 41 saying they have. About half of those people also admitting they've already formed an opinion, and 8 with a bias. Legal experts say some familiarity with the case isn't necessarily a reason for a juror disqualification.
But just because you've heard about the case doesn't mean that you are automatically excluded or you can't be sat as a juror. You really, at the end of the day, just need to be able to say, I've heard this, I understand generally what the case is about, but I'm able to keep an open mind. And that's those decisions that are made with the judge's sidebar.
Reed and her legal team leaving court for the last time this week.
Pleased with the way the choices are going?
So far, so good. So far, so good.
With supporters once again outside wearing the color pink.
You know, they're going through the process, and what we need is a fair and impartial jury.
New documents also filed in court on Thursday, including this notice of discovery by the state, which refers to DNA testing from Bodie Technologies. The lab results are connected to a piece of hair that was discovered on Reed's SUV after O'Keefe was found dead. Also in the paperwork, Reed's attorneys arguing for a fair cross-examination of Trooper Michael Proctor, the lead state police investigator on the case. The state has argued they don't want a jury to know he's under an internal affairs investigation for his handling of the case, but Reed's attorneys firing back. Quote, the fact that Trooper Michael Proctor is facing potential professional disciplinary action precisely because of his conduct in this case means that he has a personal interest in the outcome of these proceedings.
Exactly. He already wants to paint her as guilty as possible so that he comes out looking like roses, which it's not going to happen because he planted taillight. And Jackson and Yannetti are going to tear him a new one, just trying to, like, I cannot wait for cross-examination for some of these people. I don't know what the Commonwealth is thinking putting them up there, but, you know, I think they're going to have a fine time questioning these investigators in the case. But just, yes, exactly. The fact that Trooper Proctor has an investigation on him for this particular case, it is absolutely relevant that it comes in at this trial. Whether there's any kind of conclusions that are found or not, we still should know that Trooper Proctor is not always on the up and up. The jury should know that. We know that, but the jury needs to know that.
And necessarily also has a bias and prejudice against Miss Reed.
Just like Michael Morrissey. If Michael Morrissey pushes for a conviction and this vindicates him if she gets found guilty. So they both have a reason for her to be guilty, a motive to want her to be guilty in this case, because it saves their asses.
Again, 16 jurors are needed, so 4 more to go. Because there is no jury selection process slated for Fridays, this entire process will continue again on Monday. We're live here in Dedham. I'm Kirsten Glavin, NBC 10 Boston.
All right, the process continues next week. Kirsten, thank you. Back in studio now, we have our legal...
So now that we talked about what's going on with the jury and we're all caught up, we're going to talk about the way the media portrays this case. And we're not going to get into a ton of examples, but just this example alone. So they did a nice little segment, told us what was going on with the juror selection, and now they have these pundits who have probably not done any research in this case. They just have experts on these shows that know nothing about the case, and they just start spewing misinformation. So let's listen to what these two have to say. And they throw in their opinions too. So it's a lot of opinion as well. Here we go.
Legal analyst Michael Coyne and our Sue O'Connell, who has been in court over the past 3 days. We're going to get into those court filings that Kirsten was talking about very soon. I have many questions, but we're going to start with the jury selection process. So, Sue, you warned yesterday about this thinning of the jury pool and what that could mean by the end of the day, and I think it proved to be true.
Yeah, as Michael, I'm sure, will affirm, court watchers and people who work in the court system say that as the week goes on, the number in the pool diminishes just automatically. That's why we don't have jury on Friday, jury pool on Friday, because who wants to go to the jury on a Friday, right? So you're going to kick it. But also what was interesting is that the number of people who raised their hand and said, I've heard about the case, I've read about the case, a friend or family member has, the percentage of people has been increasing that are saying that. Also people who are saying, I've already made up my mind or I have a bias. So as I think it's going to get a little bit difficult.
Well, it might be because, Judge Cannoni put a 200-foot buffer around the courthouse. So any of the protesters that were out there on those days before when Karen Read had hearings, they're still out there. But now they're spread around town in these smaller groups, but they're still large enough to make an impact and to make the whole town see them. And basically, you can't get anywhere in the town without driving past one of the people or one of the groups that are supporting. I mean, they're not even protesters. They're protesting injustice, but they're really there to support a woman who they believe, and very rightfully so, should, if they've looked at the documents, believe that she's innocent and that she is being framed, because that's what the evidence shows.
As we're doing shows like this and the trial has started, people, if they're paying attention, they're going to know about the case. That does not disqualify them,
right?
From serving, but it just is interesting. And each time when the question's asked and all the hands go up, everyone laughs because it's like, of course,
You've been tweeting about this too, and I've been following you on that. So we'll share one of those tweets with our audience. And at the same time, I'll ask Michael Coyne to talk about the process from here going forward. We're going to get...
What does her tweet say? 41 of 52 say they have talked about the case. This is higher percentage than prior days. 20 of 52 say they have formed an opinion. This is higher percentage than prior days. And 8 out of 52 say they have a bias. But she doesn't say if that's higher than the other days. I don't think so. I think it was probably even or similar. There weren't too many people who had biases in the case in the first couple days.
To 16, they will all listen to the testimony, but only 12 of them will deliberate?
Yes, that's correct. You have 4 alternates then, so that if during the process of the trial someone gets sick or they've got an emergency at work or somewhere else where they cannot continue, one of the alternates will then slot in. If at the end of this process we have our 12 jurors still intact, then they will be the only people deliberating and hearing the resolution of the matter and arriving at a decision.
You don't know if you're an alternate or not. When you're chosen, they usually don't select if you're an alternate until you start deliberating or, sometime throughout the trial. You are to be paying attention like you are a juror. They don't tell you you're an alternate. They randomly select numbers, usually at the end of the trial. I don't know. I mean, it could be done differently in different courthouses, obviously, but from what I've seen in trial, they usually pick juror's number randomly and say, juror number 8, okay, you're an alternate. Juror number 17, you're an alternate, and you go over, you're here, and the rest of you go deliberate. That's usually what happened, or that's what I've seen happen. So I don't know, it might be different. I don't know what this guy's talking about.
decision. Those four will likely still, the four alternates will still be kept in case something happens during deliberation. But other than that, they will not participate.
Well, let's talk a little bit about the potential evidence they will hear. We saw in Kirsten's reporting that there is some DNA evidence that the state would like to introduce. Apparently, some kind of DNA found on the back of Karen Reed's SUV. I don't suppose we know exactly who it belongs to, but what do we know about it so far?
Well, the likelihood is the government wouldn't be introducing it if it didn't belong to the decedent. And so what they want to do is connect the vehicle, the back of that vehicle, with Mr. O'Keefe to show that that's likely how he met his end. And the DNA evidence becomes incredibly important. You know, we refer to it these days as the CSI effect. The jury has seen enough of these TV shows. They want to see the connection medically, scientifically, between what you're saying took place and what actually took place. And when you don't have that, the juries now start to question the strength of.
But the problem is, the investigation is shoddy. So nothing about this investigation can be believed. Was that hair even found there? Did someone plant it? You can't, just because it says DNA matches and it's John's hair, that doesn't mean anything. I don't believe the Commonwealth. I don't believe half of their experts. And by the way, let's talk about their experts. So they don't have any. They have very few experts or very few people that they're calling besides witnesses and things like that, or investigators. But where's their experts that are going to be claiming that Karen is the one that backed up into him? They have to prove that. And Karen's team, on the other hand, they have an accident reconstructionist, and I'm sure he's going to show that she did not do it and why, and all the scientific reasons behind why. So what does that say regarding? I did post, if you guys didn't notice, I posted in the community tab the list of both defendants and prosecution's witness lists, and it's very interesting. There's a lot of names we know on there that we've been through before, if you've ever, been paying attention to these, to what's going on in this case. All right, so.
And of course, what the defense has been arguing in these pretrial motions is that there's some kind of law enforcement cover-up, Sue. And there are people outside the courthouse who are protesting this fact every single day. But they're doing it in a unique way now to get within the buffer zone. Can you explain that?
Yeah, I mean, there's a couple of things going on here, Glenn. And I think it's important to remember that someone is dead, right? Someone died tragically. And someone is on trial for that death. She may or may not have done it. There's a lot of tragedy that's happening in this courtroom. And then when you're outside and people are wearing pink and happy to see each other and honking their horns, it's as if there's no tragedy that's unfolding here.
Yeah.
Absolutely.
You know what the tragedy is? Yes, it's a tragedy that John is gone. It's more of a tragedy that the people inside 34 Fairview Road covered it up and then framed an innocent woman. And those are the things that we need to be talking about. And that's the reason why people are standing out there. And it's not just because we're celebrating someone's dead. No, I'm not out there, but I'm speaking for them in the sense that, I'm supporting Karen Reed too, cyberspacely, from cyberspace. But they have brains of their own, and the reason that they're out there is because they've looked at the evidence. So for this woman to be like, it's just so annoying that they're all so happy to see one another. They're celebrating their right to free speech and to support an innocent woman who's being framed. So if that upsets you, I'm sorry.
Absolutely. So, of course, the buffer zone idea was to try to insulate the jurors from,
But why are we not talking about the fact that the buffer zone is infringing on people's First Amendment rights? She doesn't care about that. She just wants people to stop wearing pink.
Being exposed to opinion when they're going in and maybe getting something in their mind. So people have been wearing pink instead of carrying Karen Reed, free Karen Reed signs, right? So what has happened is it's turned into a bit of a celebration, as you can see, where people are happy to see each other, cheering Karen, which is their right, and they're able to do it.
Absolutely.
But the festival part of it and the circus part of it is now starting to creep up, and we're just in jury selection. One of my colleagues at another station inadvertently wore a pink shirt today to work in the courtroom, and you would have thought that he had come out and been standing up with a bias that he said he believes, and he just accidentally did it. Yeah. And the craziness that's already happening from the outside agitators, again, they can be very upset about what they think is happening. They can be upset about law enforcement overreach or cover-up. All of those things are legitimate. But the celebratory aspect of this is really starting to get under my skin.
And Glenn, for those who have never...
They're not celebrating. I don't know what they're celebrating. These people are upset and they're angry. but they're not violent. They're not going around heckling. They're not like being rude like some individuals have. And those people you are dealt with. And usually it's the other side who are the hecklers, like the Grant Smith or Ellis or Grant Ellis Smith, who we're going to talk about in a minute. He's one of those that just wants to incite, disruption. And he wants to be like the other day, Karen was getting out of her car and he's like, Are you spending the night with Alan Jackson in the same hotel? Like, are you a child? Come on. Yeah. So, all right. So as you can see, the media, they don't actually know what's going on in the case.
Ever been to that courthouse? It is a very small courthouse.
Yes.
And that's what makes this problem that Sue has just talked about even worse.
Well, you know what's so interesting in this part of our discussion is that the threshold to hear potential evidence outside of the courtroom is far different than the threshold to get evidence introduced in court. So we saw in Kirsten's report that Trooper Michael Proctor, the state trooper who is the lead investigator in this case, is under internal investigation. Our investigation unit knows that that's related to the Karen Reed case. The question now is, should the jury hear that information?
Yes.
No, not yet. The fact is we don't admit arrests of individuals. We don't admit pending disciplinary actions generally. And the reason for that is nothing has been established yet. It's an allegation until proven. And so
you might not do that if it's unrelated to the case that you're talking about, but he is under investigation specifically because of this case, because he planted evidence, because he lied on police reports, because he's best friends with the Alberts. This is why.
Minimum, you'd have to have an outcome to that decision to make it relevant such that it could be admissible in evidence. The fact is people make allegations all the time that ultimately turn out to be untrue. So it wouldn't make sense for the jury to hear it and then turn out they have to be instructed at a later point, oh, disregard it, that was not of any consequence, because juries don't disregard it.
You don't just disregard something that is very intertwined with the case that you're on. I mean, I get what he's saying. If an investigator was under an investigation by his own organization and you have to put him on the stand for some unrelated case, yeah, I get you're not going to necessarily go into all that, but you still need to look at his credibility, and internal records like that go to whether he's credible or not. So you need to allow that
evidence once they hear it.
We could continue this conversation for 30 minutes, but we have 6 to 8 weeks.
All right, so they're done. So that was a good little sample. That was last night, and these are people who apparently were even there. That woman, it made it seem to me like she was in the courtroom yesterday, because she had all those deets, but maybe not. I don't know. But either way, they don't really know much about the case. All right, so this is the infamous Julie Grant. I used to love her on Court TV, but now I can't side with her. I can't trust her. She's totally incredible to me now, after the fact that the way she's been portraying Karen Reed in the media. And this, I'm going to play for you a portion of a conversation she has with her guests on, and they're talking about the protesters and that they're all paid by Karen Reed to go protest outside the courthouse. This is what these people are coming up with. I mean, this is an older clip, but it's just going to show like what is going on in these people's heads. I don't know.
This case is police officer John O'Keefe, a Boston police officer who was dating Karen Reed, and the relationship at the time of his death was very strained. Now, and when
their relationship was very strained. Now, that's not even confirmed. So why are you going around spouting that off, Julie Grant? Oops, why isn't it playing? There we go.
Wednesday, state police seized 2 phones belonging to Karen Reed, and this is in connection to an...
So this is when Turtleboy was still in jail, and they seized his phones and her phones. while he was in jail, because they monitored his calls and found that he had been speaking to Karen. So now they want to pin the witness intimidation on Karen, and she had nothing to do with it.
Ongoing investigation into...
I mean, there is no witness intimidation, but she had nothing, you know what I mean.
Witness intimidation. Now, this probe is being conducted by a special prosecutor who was referred to this case by the Norfolk County District Attorney's Office. The DA there, Michael Morrissey, we've seen him front and center at this prosecution of Karen Reed for the death of John O'Keefe. And we've also heard a lot about that blogger, Aidan Kearney, better known as Turtleboy. This is him. He's come on court.
That blogger, Aidan Kearney. It's Kearney, and he's much, much more than just a blogger, but okay. Everybody wants to refer to him as a blogger. His blogger, or his blog, is his journalism. That is his newspaper to us every day. So, blog or no blog, whatever you want to call it, blog, article, post, he's giving us the information, and he's reporting the true information, Julie Grant, not, sensationalizing it for court TV.
TV. He's a huge supporter of Reed's defense team, and he was indicted. This is part of this investigation that's running parallel by the special prosecutor, indicted in December for witness intimidation. Prosecutors are alleging that Turtleboy bullied a witness who was set to testify in front of a grand jury. Now, these phones are reportedly not connected to the murder case, so understand that they're not part of the homicide case involving victim John O'Keefe, that police officer who lost his life. But we're wondering, how might the seizure of these phones affect the trial that's coming up in that case? I mean, we're weeks away from this trial. Let's bring in our guests. I have a tremendous power panel. My goodness, look who's joining us this morning. Attorney and law professor Dante Mills is with us. Criminal defense attorney and former prosecutor Michael J. Brown with us as well. And the state attorney in Palm Beach County, Florida, Dave Ehrenberg. Wonderful to see you all this morning. Oh boy, how is this going to affect the trial coming up? Dante Mills, may I start with you, please, Professor?
Yes, good morning, Julie. I love talking about controlling the narrative. I think the defense team has done a fantastic job in this situation. I think what you're looking at is really when politicians, for example, run for office, a lot of them don't want the attack ads to come directly from their campaign. So what they'll do is they'll have super PACs run the attack ad, but of course it's in coordination. I think it's the same thing here. The defense team didn't want to be out front with the bullhorn, but they found somebody who was willing to do it, who believed in the cause, so they coordinated with them.
Okay.
Believe Karen Reed was...
he's going to say paid too, but yes. Okay. So just because Turtleboy has a bullhorn, I don't think that's why she chose him. I think she chose him because he's honest and truthful, and he's going to get the message out.
Having conversations with him, that has to be the probe, and why they took the phones to see what the communication was. But she was probably putting a battery in Turtleboy's back. Saying, yes, this is absolutely true, and if you want to talk about it, feel free. You have my authority or my...
And so they're trying to pin the intimidation on her too, because then it can be a more solid case for Turtleboy, but also it's just a distraction. Seriously, that's all this is.
My blessing to do so. But I think it works very well for the prosecution and gives people something to talk about, which will cause doubt in her murder case, and it's worth the risk.
Dante, I appreciate what you're saying. Thank you for all of that. Michael J. Brown, to you next, please. How might this affect the trial?
Good morning, Julie. The concern I have from a defense standpoint is, when the prosecution goes forward and now makes these claims or allegations that she may be involved in some witness tampering or intimidation, if she chooses to take the stand, the judge may have to make a ruling of whether or not the prosecution can inquire about that. And that's a really damaging and damning piece of evidence if it gets out before the jury that she, in fact, in some way tried to prevent certain witnesses from testifying truthfully against her. It's just a...
She didn't. She never did.
Bad look for the defense, and it could be very damaging.
Yeah, I appreciate that. A great point as well. Last but certainly not least, Dave Ehrenberg, want to get your take on all this, please.
Well, I agree with everything that's been said already, Julie. I think the power for prosecutors of a witness intimidation claim is that it's twofold. First, it's its own crime, but also it shows consciousness of guilt. Of course, why would you try to intimidate witnesses unless you knew you were guilty? What do you have to hide? So it's powerful in front of the jury if that can get out, and that's why the seizure of the phones could be important evidence, no matter what the blogger says outside the courthouse.
Right. No, appreciate it, Dave. Okay, so thinking about this, something that really hit me. I mean, it's always been in my mind that, okay, with these two narratives, somebody's lying here, but somebody's lying big, right? With this big development. As we're drawing closer and closer to the trial date, we're thinking about these seized phones. And then, of course, there's the question, is Karen Reed part of these protests? Is this a paid mob? That is a fair question. You know, they're looking at her phones. Did she have anything to do with paying anybody to do this or to do any witness intimidation? And our Court TV cameras, we've been there for all these hearings. We see the protests. I mean, it's really crazy. I mean, look at this truck with...
Yeah, people raise money to run that ad, and then the ad drives around the courthouse. People pay, like, donate. You know, they certain individuals who are in this... in the protests, you know, involved in it, they raise money and they pay their hard-earned money to have that truck stand out there and shout justice for John O'Keefe and for Karen Reed. So they pay individuals who protest, pool their money together and do this.
With the sign, how much did that cost to put that on the truck? And this has caused lots of contention between Canton residents and law enforcement officials. And so either the police are really engaged in this grand cover-up, I mean, and this is grand, you know, or is she behind these protests? Let's talk about these things. Let's go around the horn, but we're going to do it in reverse order this time. Dave Ehrenberg, start us off. Do you think somebody's lying here really badly?
Sure looks like it. If you can get the video of those signs of the protesters out there, there's something interesting about those signs. They all look like they're made by the same person. This doesn't look like some spontaneous outbreak of a concerned citizen. Look at those signs. Look at the font. Look at the print. It looks like they're made by the same company, the printer, the person, and the people out there. I wonder if they've been paid. I wonder if they're part of an organized group. This is what happens when you have a defendant with means or with support in the community. You can get this PR war. It's been already said. They control the narrative, and because prosecutors are elected in their communities, defendants think they can intimidate prosecutors by a show of political force, by a show of protest. But in the end, we just follow the evidence and are supposed to.
Are you kidding? You think because she's got money, she's just doing this to throw the prosecution off? Get out of here, buddy. Like, what are you talking about? Karen has nothing to do with the protests. She loves that they're out there. She loves that they support her. But she didn't start that. She has nothing to do with it.
To do justice regardless of what the polls say.
That's the truth, Dave. You are right. You know, and I would love to hear, you know, all of your answers on this. How, throughout all your years of experience, all of you trying cases, you know, at criminal courthouses, have you ever seen a mob like this? I mean, you know, there's so many court dates. You know, it's hard to get victims to show up. I remember being a prosecutor, it's hard to get your witnesses all together, and yet you got these people taking off work to be there. I mean, it definitely raises questions.
And what does that say to you? People are taking off work to be there, paying for signs and supplies for signs out of their own pockets. Yeah, what does that say to you when all of those people are there to support someone who supposedly ended the life of a cop?
Dante Mills, I see you with a big smile there. Let me go to you next, please.
Yes, I agree 100%. I do think that there's a part of this that's put together, but I think it's the right thing to do for her defense team. Again, I have to keep going back to control the narrative. They're doing a fantastic job. As we heard in the clip, the woman talking about this case is impacting every single person in that county. When has that ever happened? But it is. And I know that we keep talking about the charge of witness intimidation, but that's just an allegation. I'm sure Turtleboy is saying, I never intimidated a witness. I just was convincing them to tell the truth. I'm impassioned about this case, and I was reaching out to people and encouraging them to tell the truth. And I think that...
And that's not witness intimidation. Does this guy not understand? Like, he just called telling people to tell the truth is witness intimidation in his mind.
This is working for the defense. The prosecution is behind the eight ball going into a case where they have to prove it beyond a reasonable doubt, where people in the community already think that something nefarious is going on and some cover-up may be happening.
Appreciate it, Dante. Yeah, I'm sure when her attorneys get a chance to speak, perhaps today about it, we've been reaching out to them after the news broke last night. Surely they're going to say, well, this is a continuation of the narrative we've already put out there, that, you know, she is a victim of this cover-up, and now this is to intimidate her by taking her phones. Or is it? Or is there something nefarious going on with her? Who knows? Michael J. Brown, take us home. Your final thoughts on this, please.
let me just take the opposition to our state's attorney, which is normally the prosecutor does a perp walk. They have press conferences at the arrest. They have numerous members of law enforcement standing behind them. So they take the control of the press and paint a certain narrative. Here you have a divided town. You have somebody who's presumed innocent, people who are passionate about her innocence, and they're simply going out there and showing their support. I have no problem with it. I think it's part of our system, and it really counters the strength of the prosecution in our country.
All right, so at least this guy doesn't think that they're paid, but the other two do. All right, we're going to watch next. This is, if you guys know Tom CPU, he's out there every day whenever there's a hearing or a trial, and he's videotaping the crowds. So if you aren't subscribed to him, go over and subscribe to Tom CPU. I get a lot of information just from watching his streams. All right, so this was a day or two ago. I can't remember. I think it was Wednesday. Tom CPU interviews Ted Daniel from Boston TV, or Boston 25 News, and he's been the only one in that area that's really been reporting on the corruption, possible corruption, the alleged corruption going on in Canton and the Norfolk County District. He's the one that's been reporting on the actual facts, not just spinning his, media sensationalism like Julie Grant. So Tom CPU interviews him. This is really short, but I just wanted to play it really quick because it's telling.
Ted, what do you think about the trial, the whole thing so far?
Well, I think I was impressed that they were able to pick 4 jurors the first day. I didn't think they were going to get that many. So we're, 12 more to go? And I hope they finish that process quickly so we can get underway and get to the good stuff, the evidence and, the arguments on both sides.
So this must have been Wednesday morning, because Wednesday they selected 7 more jurors. So at this point, they only had the 4.
You obviously have more documents and you're privileged to more information.
Yeah.
What can you tell us that you can't necessarily go out there and say possible? Is that?
No, I don't do that. I mean, pretty much everything that we've seen, we've reported. And I think you guys are pretty familiar with all the documents too. I feel like there are people who are following it, like you, just as closely as us, who are in kind of the mainstream media. So I think most everything's out there. I think it's going to be interesting to see. I think it's going to hurt the defense that they're not able to, in opening statements, come out and point fingers. To me, that seems like, so they're going to have to weave it.
I agree that it's going to be more difficult to get in their theory, but it's so obvious that once they start questioning these people, their stories are going to crack. Come on. Play.
In through
hitting the button.
And I see that as a challenge for them. But I think that she had to let the third party in, or that would have been a huge grounds for appeal.
What do you think the challenges are for the prosecution? Like for the prosecution, the prosecution has hurdles they have to get over, obviously. What do you think their hurdles are?
So, she is innocent until proven guilty, and all you need is reasonable doubt. And when you start looking at some of the weird things that happened in this case, and if the jury gets to hear some of those strange things that I don't think happen in 99% of the cases out there, I think, if you have a jury that's vested and listening, that they might have some of the same questions that everybody else has.
Yep.
How do you think it's going to end?
I don't know. I don't want to handicap it. I don't want to predict it because I could be wrong. I don't know. I think second-degree murder was a pretty heavy charge for this crime.
Yeah.
So that's essentially second degree is not premeditation, but deliberate, right?
Mm-hmm. Yep.
So originally she was charged with manslaughter, like unintentional manslaughter. She didn't mean to do it. Later, they indicted her again, the federal jury did, and got her on second-degree homicide, which means she did it on purpose. there was malice, there was intent. And now they can get her on either one. So, because both of those charges are still in play. So they could get her on either charge or both, obviously. And that's crap.
So she didn't plan in advance, but she wanted to kill him or committed a crime where she knew that she could kill him in the process. And that's a pretty heavy charge.
All right, one more question. The significance of the courthouse itself with the Zacco Vanzetti trial back then, and this trial here, and the potential.
He's referring to another trial. It was like, I think the turn of the century or something, and there were some corrupt cops doing something similar in their case, and pinning it on some innocent guys, I believe. I don't know the specifics or the details, but they are talking about that, and it basically, like, it was huge. It was a big deal in the Norfolk County District, and it was in that same courthouse, by the way. So yeah, there's that. Oh, and then one other thing I wanted to say about the getting her on manslaughter and homicide is that why is my brain not working? I was gonna say, I keep losing my thought. Something about, to get her to plead out and just say, yeah, okay, I think that they did the second degree of homicide so that they would get her to just take a plea deal on the manslaughter, and she wasn't going to sit down and do that. But that's what I think happened. I think they tried to get her on the manslaughter or try to get her on second degree homicide for that reason.
Of what it possibly could be on the fringe, what do you think about?
All right, help me understand what the question.
The fringe of it actually being a police cover-up and actually people being involved and all the things that the defense is saying. That all comes true, right?
Right.
Hypothetically.
Okay.
What do you think this courthouse with Zacco and Vanzetti, you think that trial and this trial together could possibly change?
The fact that the feds have already looked at this and we don't have any, I think if anybody was going to come in, if anyone was going to come in and say, hey, we found something, stop this, it would be the feds. That hasn't happened. I'm not sure if it ever will happen. So I think I would have put most of my eggs in the basket of the feds to do that. And I don't know. I think that this is going to continue, and I don't think that we'll ever. I think at the end of this whole thing, there's still going to be a lot of people who feel one way, and a lot of people. I don't think we're ever going to get this resolution that maybe people want.
Listen, thank you. Yeah. Have a great day, Ted. Good luck.
All right, so then there's that. So I want to just correct myself. So the Zacco and Vanzetti trial. So it took place after the 1920s. The jury convicted, so July 14th, 1921, the jury convicted Zacco and Vanzetti of first-degree murder, and they were sentenced to death by the trial judge. Italianism, anti-immigrant, and anti-anarchist bias were suspected as having heavily influenced the verdict. A series of appeals followed, funded largely by the private Zacco and Vanzetti Defense Committee. The appeals were based on recanted testimony, conflicting ballistics evidence, a prejudicial pretrial statement by the jury foreman, and a confession by an alleged participant in the robbery. All appeals were denied. By 1926, the case had drawn worldwide attention as details of the trial and the men's suspected innocence became known. Zacco and Vanzetti became the center of one of the largest causes célèbres in, what does that mean? One of the largest, what is that word? French. What does it mean? An issue or incident arousing widespread controversy. Okay, so yeah, it had a lot of widespread controversy, and a lot of people believed that they were innocent. And there is a picture of the two of them, Sacco and Vanzetti. All right, I don't know which is which. Vanzetti was left, and Nicola Sacco was right. All right, so that is interesting, huh? That one of these cases is back in the same exact courthouse. So I talked about him before, this Grant Ellis Smith guy, or Smith, I don't know, what's his name? Grant Ellis Smith. Yeah. Okay. So this is Law and Crime, Anjanette Levy. There we go. Words are fun. All right, so this is Anjanette Levy on one of her streams that she does on their YouTube channel, and I think it goes on the TV too. Anyways, so it is Turtleboy versus Grant Smith Ellis. They're arguing back and forth about this case and about the facts, and this just goes to show how misinformation by the media shapes other public opinion. And this guy, so he claims to be media or something, but he acts rude, and he's just, I mean, nobody really, I don't know. Every time I see him on like Tom's stream or something, people try to avoid him. He seems rude. He is always shouting rude things at Karen every time he's there, trying to get in front of her. So anyways, so this is Grant Smith Ellis, or Ellis Smith. What? I can't remember. What did I say? Ellis Smith and Turtleboy talking back and forth. So this is going to be interesting and fun to watch.
So if you've been following this case, you know how incredibly contentious it is with the Free Karen Read camp and people who think that Karen Read is guilty and that the evidence points to her as killing John O'Keefe. So in the Free Karen Read camp, the leader, really, in my opinion, of that camp is Aidan Carney. He goes by Turtleboy. He's a journalist. He says he's won some awards. He's award-winning. And we also have Grant Ellis. He's a law student who believes the evidence points to Karen Read's guilt. So thanks, both of you, for joining me. I want to start with you, Aidan. You've been following this.
He's a law student. Okay.
From the very beginning, and you believe that Karen Read is innocent. Why?
The autopsy photos are inconsistent, and the FBI agrees with somebody who's been run over by a car. John O'Keefe was not run over by a car. He had no broken bones. He had no bruises anywhere from the nose down. He had a 3-inch laceration in the back of his head. He has dog bites, what are clearly dog bites, on his right arm exclusively. There's two witnesses, Lucky Loughran, the plow driver, who drove by the scene at 2:30 at 34 Fairview Road and reported that not only did he not see a body 12 feet from the curb, that if there was a body there, he most definitely would have seen a body there. Ryan Nagel, also, who was directly behind Karen Read when she pulled up to 34 Fairview Road, reported that John O'Keefe was not inside the car and John O'Keefe was not outside the car, and that Karen Read's taillight was in perfectly pristine condition. So if John O'Keefe was not inside the car and John O'Keefe was not outside the car, then John O'Keefe certainly must have been inside the house. This is backed up by the fact that Apple Health data shows John ascending and descending 3 flights of stairs between 12:21 and 12:24, which Karen Read's phone does not, indicating that they were not in the same place because Karen Read does not have steps inside of her car. Additionally, of course, Jennifer McCabe, undoubtedly, who was inside the house and is the sister-in-law of Brian Albert, the homeowner, undoubtedly, and the FBI investigation confirms this, Googled how long to die in cold at 2:27 a.m. A Google search that she then subsequently deleted before handing over her phone to police. She also deleted all of her calls between 5 and 9 a.m., including 2 very incriminating calls to her sister, Nicole Albert, at 6:07 and 6:08 that lasted durations of 9 and 7 seconds, which she deleted from her phone, which is extremely suspicious and evidence of consciousness of guilt.
Okay, so there was a lot there, but I do want to say, we don't know exactly what the FBI expert said. We know what the defense says the FBI expert said about the injuries and whether or not they were consistent or inconsistent with the.
Okay, but he's not going to lie in court to the court. He said to Judge Cannoni that is what the FBI reports will be, or how, what they're going to say. He can't just lie. People, called somebody out on my channel that had a comment like, oh, but keep in mind that defense can fling lies and, you know, hurl all the lies that they want. I'm like, no, they can't. Defense attorneys have to follow the same exact code of ethics, you know, standard ethical practices for every lawyer, not just if you're a defense or a prosecutor. It's for everyone. So you can't just lie. You can't just lie. That doesn't mean that people don't, but if you get caught lying in court, or if you are proven to have submitted something that you provably knew was true or false, or I mean, if you were submitting something as evidence which wasn't, or, you know, then I don't know. Yeah, it's just crazy to me that these, I don't know. Anyways, sorry, I kind of lost my train of thought there, but it's just crazy to me, all of this inconsistencies.
Hit by an SUV. I want to turn to Grant now. Grant, why do you believe the evidence points to Karen Read being guilty?
Well, I think there's really two important views on the evidence related to Karen Read's guilt. The first is what is not true about what Aiden was just talking about. So let's take it one by one. And Anjanette, I think you pointed it out rightly. The FBI expert that Aiden's referring to was only provided 2 extractions by Mr. Yannetti, Karen Read's counsel. But what Aiden neglects to mention is that the FBI conducted a separate analysis, this time using Axiom and Celebrite. And the conclusion of that analysis was that the searches were conducted at 6:23 and 6:24 a.m., and it was done at the behest of Karen Read.
Does that even make sense? Do people really believe that 2:27 a.m. search was not done? Like, that is what boggles my mind. We have phone data of Gemma Cabes as she Googled at 2:27 a.m. house long to die in cold, and apparently the people on the McAlbert side totally disregard that. I don't know why or how, but they just in their minds have said, okay, it wasn't there. Doesn't mean, okay, so if the first cell expert downloaded Jen's phone and it wasn't there, but they used this older Cellbrite version, I mean, we can check. We can use that Cellbrite version again and try to run it and see, you know, we can try to prove them wrong to see if that piece of information didn't come up, because they're saying in their first Cellbrite search, it was the wrong version of Cellbrite that they used. So it didn't show up, the 227. So we weren't trying to hide it from you. It just didn't show up. But they still argue that it didn't happen because they have an expert say that it was actually a tab from 227 that she had open, or from that she must have had from before, and it really reverted back. Like, that doesn't even make sense. What? It doesn't make sense. It was a Google search at 2:27 a.m. I mean, I don't know how you can dispute it. And the FBI says there's no disputing it either.
That was the timestamps. And the Celebrite internal expert himself is a witness for the state who will confirm the timestamp of those searches. So that's to address just a primary falsehood. So that's one reason why I think there's some evidence of Karen Read's guilt. Going to something else that Mr. Kearney was talking about, Mr. Kearney knows the evidence in this case shows that John O'Keefe's Waze data, does not show him arriving at that house until 12:24. So the 3-second window where Mr. O'Keefe at 12:21 a.m. in his Apple Health data went up and down 3 flights of stairs in 3 seconds is entirely an errant and unrelated piece of information.
So do you see how the media and the Commonwealth has just like shoo-shooed away all these things that are wrong with the case? Like, oh, no, it's he didn't go up those stairs. That's all wrong. He wasn't even there yet. But what are you going to take as more truthful? Your Apple data from his Apple Watch or a Waze Maps system? I don't know. I think the majority of people have iPhones. Well, I don't know what the breakdown is between iPhones and Androids, but most people, I mean, iPhones rule our world. So let's just face that.
information if the Waze data, which it does, confirms that Mr. O'Keefe didn't arrive at 34 Fairview until 12:24 a.m. Furthermore, there's also evidence that Mr. Kearney doesn't even address, and the omission of it is so telling as to Karen Reed's guilt. Mr. Kearney doesn't address the voicemails from Karen Reed right after 12:45 a.m. when she is alleged to have hit John, screaming that she effing hated John, that he was a pervert, and that he was sleeping with other women. And what else?
I'd be saying those things too if my boyfriend, I caught him cheating. Yeah, I'd be mad. I'd be saying some similar things. It's not uncommon. If you think that your partner, significant other is cheating on you, it's not uncommon to say bad things to them, things that you regret. And you say it in the heat of the moment, and the next morning you're sorry and you apologize. Although she didn't even get that opportunity because John was already dead at that point. Unfortunately, she got mad at him because he wasn't responding, and that's her right to do. She was, they've had this as an issue before where he would leave and go out drinking and not come back, and we'll talk about that too in the next segment that I have for you. But yeah, it's not unheard of if you're angry to leave a nasty voicemail to your spouse or partner, or to say something nasty to them in a text or whatever if you're fighting with them. She was annoyed because she dropped him off. She probably thought he was going to either show up at home, get a ride from somebody, or she'd have to get up and go get him. So at this point, it's 5 a.m. She's angry at him and he's not back. And she's probably annoyed. Probably annoyed that she has to figure out where he is. She doesn't know what happened. She doesn't know that the McAlberts did something to him and threw him out there on the lawn, allegedly. Just to cover my ass, allegedly.
Does Mr. Kearney not address that just 1 month before John's death, Karen Reed herself started an affair with a federal agent? I believe.
Okay, she did not start an affair. They talked about in court that there were some flirty text messages or whatnot, but that was it. Like, that's not an affair. She probably wasn't getting the attention. I don't know if she was still with John or what, with this Brian Higgins guy, but she probably, if they were having a rocky go at it, her and John, she might have been, confiding in Brian. And that doesn't necessarily mean that they were in a relationship or having an affair. She might have been confiding in somebody who she thought was maybe someone who had more understanding in the situation if he was, friendlier or something with John. I don't know.
Mr. Kearney knew about this affair and covered it up from the public to try to protect Karen Reed in the lead up to this trial. And that federal agent that Miss Reed was cheating on Mr. O'Keefe with on the January 15th, 2022 Patriots game, that agent went over to John's house, and Karen followed that agent down to the basement on his way out and gave him a kiss and said to him, "Federal agent, I know where the cameras are, so I know that this will not be caught on camera when I go to kiss you." And the reason why that's relevant, Anjanette, and this goes to the last thing I want to talk about with regard to Karen Reed's guilt, is that there were 17 ring videos deleted between 1 a.m. and 5 a.m. from John O'Keefe's ring system.
Karen didn't even have access to John's ring system. It was on his cell phone, which the Massachusetts State Police had in their custody, and all the people in the McAlbert's house. So if she was deleting things from 1 till whatever, that was not her. Not her.
Karen Reed had control over, according to John O'Keefe's niece. And so that, Anjanette, coupled with the fact that Karen Reed went back to Fairview Road before going to Jen McCabe's, is evidence that she saw the body, had a panic attack, had a meltdown, and then tried to bring witnesses back to the scene, knowing that body was there, which is why Karen Reed started screaming before she got past the tree line coming up to Fairview.
That makes no sense. None of that makes sense.
Road when she went back to the scene with Jen McCabe and Kerry Roberts. That's the reality.
So, Aiden, Grant threw out a lot of information in there, and a lot of what Grant said is laid out in some prosecution documents, particularly the one that was pushing back against the motion to dismiss filed by the defense. And there really is some information in there in that document that is inculpatory, that makes Karen Reed look bad, and it does point to her as the person who killed John O'Keefe, that maybe backed up and hit him. What do you say about those voicemails where she is calling him and cursing at him
let's
after the fact, allegedly after she hit him? What is your response to that?
The Commonwealth would have us believe that Karen Reed, after intentionally striking John O'Keefe with his car, did perhaps the most incriminating thing she could do and leave angry voicemails with them. That is the last thing. To me, that is more exculpatory than inculpatory, because a guilty person would not leave a message saying, I hate you, immediately after hitting someone. An innocent person was. A person who was upset that they thought their boyfriend went out and got drunk and didn't come home. That kind of person. People have left voicemails like that with their loved ones before when they get upset with them. That does not make them a murderer. That does not explain why John O'Keefe has dog bites on his arm. That does not explain why Lucky Loughran did not see a body at 2:30 a.m. That does not explain why Ryan Nagel did not see John O'Keefe inside or outside of the house. And by the way, the Apple Health data is substantial, and he's wrong about the Waze thing. He just made that up. The Apple Health data uses an internal cocoa clock, which measures seconds from the year 2000. It is the most reliable form of telling time possible. And it shows that John was ascending and descending stairs from 1221 to 1224. It's Apple. I mean, it's freaking Apple. We don't have to explain the reliability that our society has on Apple. If Apple Health data is unreliable, then we have nothing. Additionally, not a single person inside that house who left that house, there was 11 in total, said that they saw a body when they left the house. Not a single person saw a body. However, I'll tell you what Lucky Loughran did see when he went back at 3 a.m. was he saw a Ford Edge parked in the exact same spot where John O'Keefe's body would be discovered 3 hours later. Remember, he did not see a body there prior to that. And then he saw a Ford Edge, and then 3 hours later, boom, a body appears there. You know who owns a Ford Edge? Colin Albert owns a Ford Edge. Brian Albert owns a Ford Edge. Kevin Albert owns a Ford Edge. And the police, to this day, have not done a single thing to track down who was driving a Ford Edge parked directly next to where a dead police officer was found 3 hours later. The same lead investigator, Michael Proctor, who we now know is close family friends with the primary and most important witnesses in this case, that he lied to a state grand jury about his relationship with them, that he was offered gifts by Julie Albert, the mother of Colin Albert, on the day that Karen Reed was arrested. She wanted to thank him and send him that. So I don't care if Karen Reed was smooching with the entire town of Canton. I don't care if Karen Reed left angry voicemails with them. None of that explains all of the much more damning exculpatory evidence that I just went over.
Okay, but Aiden, you have to contend and you have to concede that I don't think anybody is saying that Karen Reed intentionally hit. I don't even think the Commonwealth is saying that she intentionally backed into him.
Oh, yes, they are.
I mean, it sounds like they think she was drunk. They got into a fight. This is the theory. She got into a fight with him. They argued. She was drunk. He may have had that glass in his hand or whatever from the bar, and that she backs into him and takes off. And maybe she didn't even realize what she did.
And then she's disagree with the Commonwealth
cursing him out.
And you disagree with
that's how I read that document.
Hold on, Anjanette, can I weigh in here? Because I think I deserve a chance to respond.
That John did that John was hit intentionally. It's undeniable. That is what they've...
No, that's wrong. Aiden, you're putting out misinformation. This is a malice theory of second-degree murder. I'm sure Anjanette can explain it to you if you don't want me to. The malice theory of second-degree murder has 3 possible prongs. 2 of them involve intentionality. One option does not. One involves recklessness as the mens rea, which means a reasonably prudent person knew or should have known that they acted in a way which could have resulted in death. It does not require intent. It does not require foresight of the death having potential to occur. It requires only that the defendant should have knew or should have known that their actions, to wit, in this case, DUIing and backing up in anger while John was around the car, had a reasonable and plain likelihood that could cause death. That's the standard. It's not intentionality. You're wrong, Aiden.
I'm actually not wrong, because actually in the filings they specifically said that Karen backed up 62 feet and hit the maximum speed of 24.2 miles an hour. 62 feet at 24 miles an hour, which, by the way, is physically impossible. We've recreated that several times, particularly in the snow, and yet nobody heard it. That is not an accident.
So the Commonwealth actually changed their theory multiple times. The first theory was that she did a 3-point turn, and when she did that, she backed into him. Then the Commonwealth realized that it was the wrong tail light that would have hit him, so they had to change their theory in order to fit the tail light thing. So then they made up the fact that she, out of a fit of rage, backed up from like 60-something feet, going 24 miles an hour in her car, which, by the way, that would be like the minimum of which a car would go in order to have the sirens go off to like tell you when you're about to hit something when you're backing up. So I think they knew that, the Commonwealth, with their recreation guy that they have. And so they made it seem like she just, out of a fit of rage, she pulled forward 60 feet and then she rammed into him backwards, and he went flying 12 feet into the lawn. Does that make sense? That's what they're saying. That's the theory, that it was intentional. They've had multiple theories, but I think that's the one they're sticking with now. But they might have even changed that since. I don't know. I can't keep them all straight, but those were the main two that they had.
If somebody does something like that, if somebody intentionally guns it at another human being, that is not an accident. So let's be clear. The Commonwealth is alleging.
But you understand, Aiden, let me quote this.
The second degree. Let me get in here. I've read the documents. You can intentionally gun your vehicle, but not intend to hit somebody, and that's how I read it. And I read through the documents, and I've read them twice. That just laying out their theory of the case was that they got into a fight. She was drunk. I mean, this was a bad relationship. It sounds like it was on the rocks, and it was probably ending. And that she was mad. She may not have even realized she hit him. I mean, that's how I read the documents.
You didn't hit you wouldn't notice he had a 217-pound body going 24 miles an hour. You wouldn't notice that? Come on.
If you were drunk, I don't know.
And not a, and by the way, both cameras on the street have ring cameras on them. Ask how many of them were pulled by police. 0. There's hundreds of ring cameras on homes and businesses between 34 Fairview Road and 1 Meadows Ave where she went. Not a single one of those videos was pulled by police. Not one. If they had just found one ring camera video with a broken taillight, Karen Reed is 1,000% guilty. But they did not do one. And the lead investigator in charge of this happens to be good friends with McAlbert's and was offered a gift by Julie Albert on the day that Karen Reed is arrested. Ask yourself why.
And I've read that in the defense filing. I want to discuss very briefly the dog bites, this dog bite theory, because, we haven't heard that really specifically addressed by the state. So I've seen the pictures. We can't show them on YouTube. I know they're out there on other channels, but we are not showing them. I've seen the scratches. They're vertical up and down. You contend they're dog bite marks, attacks from Chloe, the dog that was in the house. Aiden, that's your contention. So tell me why you believe so strenuously that John O'Keefe was attacked by a dog, because there's no mention of that in the information from the medical examiner in the prosecution documents.
I suggest everybody watch Attorney Melanie Little's interview with canine expert and dog bite expert Garrett Wing on January 13th. You can check it out on YouTube. He is a person who has seen thousands of dog bites over the years and knows exactly what they look like. And he believes with absolute certainty that those are dog bites from an untrained police dog. Police dogs are taught specifically to latch onto a victim's arm. They will not let go. They're taught to hold on. But an untrained dog like Chloe, who, by the way, also according to Canton Animal Canine Control Records, sent 2 other people to the emergency room and biting them. An untrained dog like Chloe would grasp onto you, and if you pulled your arm away, it would cause marks like that. And it's undoubtedly that those are clearly lacerations, not abrasions. We all know what an abrasion looks like. It's insulting to us to suggest that those are abrasions.
Right.
Keep in mind, medical examiners don't see dog bites a lot because most people who die are not killed by a pack of wild dogs. So they don't really see a lot of dog bites on dead victims very often.
Yep. All right, Grant, this is our last point, the dog bite theory. Your response.
Yes. Thank you. I'm sorry I forgot to address it earlier. This is simply not at issue in the case, Anjanette. The defense has said there's no dog DNA at issue. It's not in any of the moving papers, as you know. What it is actually a microcosm of everything that Aidan Kearney reflects in this case, which is we, as you know, Anjanette, in the legal profession, are...
Okay, wait. The dog bites are a microcosm of everything that Turtleboy represents? What? What is this guy on? Oh, I don't know. He's on something. He's happy in his own little world, but it's not in reality, that's for sure. I don't even know. So what did he just say? Let's go back.
Dog DNA at issue. It's not in...
Okay, so there's no dog DNA because the state never tested for dog DNA. They never tested his skin swab. Like, they never swabbed his skin and did any kind of testing for that. They don't know. They don't have a test or results from his arm. They didn't do that. Why didn't they do that? Don't you wonder?
In any of the moving papers, as you know, what it is actually a microcosm of everything that Aidan Kearney reflects in this case, which is we, as you know, Anjanette, in the legal profession, are subject to the federal rules of evidence, which I keep in my pocket at all times. Those federal rules of evidence limit what can come in a trial for a reason. Mr. Kearney, however, in an attempt to poison the jury pool, can say whatever he wants in the hope that it will potentially cause one juror to hold out and vote for a not guilty verdict. However, because the fact that dog DNA is not an issue, and the fact that these autopsy photos came out from the defense and were hypersaturated, it's all an indication that this is a distraction, and it's not even going to be brought up in the case. And one more thing to bring this...
Okay, so even if you can take away the dog bites, how do you explain the, 2-inch gaping wound on the back of his head, the swollen, both eyes swollen, and his face all swollen, and his fighting hand, his punching knuckles swollen. Why would those all be bruised and swollen? They didn't, you know, I mean, even if you take the dog bites out of the equation, the way that he was found does not fit with a car accident. It just doesn't.
This fact. It is very, very, very clear that Karen Reed probably did not intend to kill John O'Keefe. But it is also clear that Karen Reed probably found the body before she went to Jen McCabe's and had a complete meltdown as a result. Mr. Kearney can't address Karen's behavior, the breakdown of the relationship.
That's the second time he said that she probably went back to the house, saw him, and had a breakdown. That's the second time he said that. There's no... Where's your thing for evidence? There's no evidence for that. That's speculation, Grant.
The exceptions to the character evidence rule and the hearsay rule for a domestic relationship gone bad in the lead up to a second-degree malice murder. He can't address any of the evidence related to Karen's statements after she did hit John. And he can't even address why Karen won't release the ring videos from her parents' house in Dighton that would show that taillight crack in that early morning. She released a...
I can guarantee that Aiden can address all of those things with a reasonable, logical explanation that makes sense if you look at it from the fact that the Commonwealth is corrupt. Because they are.
Still, she won't release the other videos. She's guilty. He knows she's guilty. He worked for her PR team. She burned him, and it's over.
Okay, so we're just making things up. PR team. See, this is the part
she worked for his PR team.
where we start making things up. But okay, sure thing.
All right, guys. I hope we can revisit this as the...
She worked for his PR team, apparently. You know, when she's not out running people over and being a financial analyst and professor and all that stuff, she was hiring Turtleboy for PR. And then she fired him. I don't know. This guy, Grant Ellis Smith or whatever the heck your name is. All right, so this last one I've never showed this on my channel before, but I do want to, since we're talking about how this case is portrayed in the media, the last clip I'm going to show you is actually this is several months ago. This came out. It was a Nightline ABC News segment. So we're going to watch that about Karen. They're interviewing Karen and her attorneys. So I just want to, since, you know, we're showing media about this case, this is part of the narrative as well. So
I did not kill.
And it's better to hear it, I think, from the defendant. She's breaking her silence by being on this channel.
Officer John O'Keefe, Reed has strenuously denied the allegations.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
Her defense, bare-knuckled and bold, is making national headlines. Her lawyers alleging in court documents that a fellow police officer was involved in O'Keefe's death and colluded with other people in a cover-up.
You're alleging that law enforcement officials in the state committed murder and that they're covering it up. Why would they want to be involved in this?
Because he's dead. I think things went too far. It was late. There was alcohol involved, but they're all family. And there's many of them involved.
After posting bail, Reed has spent much of the past 18 months in and out of court awaiting a trial date.
And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Prosecutors allege that Reed hit O'Keefe with her car after getting into an argument earlier in the day, leaving him to die in the middle of a snowstorm in January 2022. But Reed says she had no reason to harm her boyfriend.
I would call him the patron saint of Canton. He was just very selfless, frugal, and I think you'd be hard-pressed to find anyone that didn't care for John.
The couple first dated in their 20s and reconnected more than a decade later in the middle of the pandemic.
So how did you meet up again?
He had reached out to me on Facebook. He said, hey, blast from the past, how's things? And when I saw his picture, his profile picture was with several young children, and then it triggered my memory that his sister and his sister's husband had passed away. And he told me, yeah, I have the kids now. I admired that. I thought that was amazing.
Soon, Reed says she became part of the family, often sleeping over at O'Keefe's house and helping take care of the kids.
He would go to work and I would stay with his niece and nephew. All of the breaks that the kids had, we did something.
But their relationship also had its struggles. Reed says O'Keefe had been relying more on her to take care of the kids and that he criticized some of the decisions she made with them.
We had had an argument on New Year's Eve. We were away on vacation, and he became incoherently drunk. And I ended up ringing in the new year with his niece and nephew. John didn't come back to our room till after 3 a.m. So that was rough. I felt very much taken advantage of. He apologized profusely for what happened on New Year's Eve, and he said, if you can't get over it, then you need to spend some time at yours. I can't keep apologizing. I don't want to keep rehashing this.
A few weeks later, they were invited to meet up with some friends at the Waterfall Bar in Canton. And there, they ran into Brian Albert, a fellow Boston police officer who Reed says O'Keefe looked up to. Albert had led the city's gang unit before commanding the Fugitive Apprehension Team. It was the elite squad responsible for taking down some of the city's most dangerous criminals and featured in the 2013 TNT show, Boston's Finest.
1 minute we're walking around, everything's fine, and then 1 minute it's not fine.
Both times I met Brian Albert, he seemed like the type of person that you'd be surprised he's out socially because he doesn't seem like he ever wants to be there.
But at the bar, Reed says there was an invitation to continue hanging out at Albert's home.
I said, can we make sure we're welcome here? Nobody extended the invite to me. I didn't hear the invite extended to you.
They drive to the Albert's house. What happens next is disputed.
So I pull at the foot of the driveway. It's snowing. John has no coat on. It's windy. So I drop him off. He goes up the driveway and approaches the side door. And as I see him approach the door, I look down at my phone.
Reed says after about 10 minutes of waiting in her car, she became irritated that O'Keefe still hadn't gotten in touch with her. And she drove back to his home where she continued calling him before, she says, she fell asleep around 1:30 in the morning. She then says she woke up before 5 a.m. He still wasn't home. She then started canvassing the neighborhood.
Just gonna drive around in the 2 square miles that we spent the preceding night.
After 20 minutes of unsuccessful searching, she called John's friend, Carrie Roberts, and Jennifer McCabe, Brian Albert's sister-in-law, who was also at his house the night before. The 3 women together now headed to Albert's home.
How soon was it when you pulled in there that you saw John's body?
Immediately. And what struck me when I saw him was his mouth was open a little bit and his eyes were shut and he had spots of blood in different areas on his face.
O'Keefe was taken to the hospital and pronounced dead. He died from blunt force trauma and hypothermia. And it wasn't long before Reed became the #1 suspect. Authorities say they had noticed a cracked taillight after they seized her car.
I had told both Jen and Carrie that I cracked my taillight. I said I just hit my car on top of everything, but I didn't look at the damage. And both women said, it's cracked, it's cracked. Calm down, you cracked your taillight. You're okay, let's go look for John.
But according to police statements, Jennifer McCabe told authorities that while they were looking for O'Keefe, Reed stated, "Could I have hit him? Did I hit him?" And when O'Keefe's body was discovered, first responders who arrived on the scene say they overheard Reed make other statements.
The firefighter said that you said, I hit him, I hit him, I hit him.
I said, I hit him. It was preceded by a did and proceeded by a question mark. What I thought could have happened was that did I incapacitate him unwittingly, somehow, and then in his drunkenness, passed out?
When you walked out of the bar, how many drinks had you had?
I had had probably about 4.
The Commonwealth says that you had 9 drinks that night. That's what the prosecution says.
I don't believe they're saying I wasn't in my right mind.
No, they're saying you were intoxicated. Is it possible that you might have hit him unwittingly in your admittedly very large SUV?
No, not possible.
3 days after O'Keefe was found dead, investigators arrested Reed for manslaughter. She was eventually indicted on second-degree murder.
3 days.
Investigators reported they found fragments.
Anytime someone is arrested immediately after something happens and you don't have actual proof, I mean, the investigation is taking place, but there's really nothing tying her to anything until you start planting taillight.
A broken glass on the rear bumper on Reed's vehicle, and that a broken cocktail glass was found by what appeared to be patches of blood near O'Keefe's body.
The victim, Mr. O'Keefe, is last observed on surveillance video with a cocktail glass in his right hand. Same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car.
In court documents, the prosecution also claims that Reed's blood alcohol level could have been between 0.13 and 0.29%.
So they give, media gives you this little tidbit of information. 0.13 to 0.29% is her blood alcohol, but they don't tell you how they figured this out, when they took her blood alcohol. So if you actually investigate this, you can tell that these readings are just completely made up because, well, first of all, they made up some fake self-deletion story that she was saying she was going to self-delete, and so they brought her back to the hospital. That was their way to get her back to the hospital so they could draw her blood. And then based on whatever they say it was, this is what we can determine it would have been at 12:30, which would have been the time that the incident happened, if she had really hit him. But this is like a huge variable. And what's the science based on that? If like a normal person who just hears it in the media would be like, oh, she was drunk as shit. But if you actually like look into the case, we know now that this is a completely made up statistic, basically to get her for the drunken driving part of it and, you know, recklessly driving away.
Above the legal limit of 0.08. In addition, they say pieces of Reed's taillight were found on the scene the day O'Keefe's body was discovered. More fragments of that taillight were found the following week, according to Canton police reports, after the snow melted, which revealed more at the scene. But Reed's attorney, Alan Jackson, has a different theory about how those fragments of taillight got there.
Those pieces of taillight were placed there after the fact.
You're saying evidence was planted?
The pieces of taillight were planted after the fact.
What does the defense believe actually happened to John after Karen dropped him off?
I think he walked into the house. I think he was confronted, was likely brought down to the basement. I think that confrontation got physical, and he was beaten. He was beaten to a point of unconsciousness.
I agree.
Jackson argues that the autopsy photos of O'Keefe support his theory and not the prosecution's claim.
Looks like he's been in a fist fight and he's been beaten. He's got some defensive wound bruises on the backs of his hand. He's got this massive laceration on the back of his head, a big giant gash, about 2.5 inches, exactly lateral, going from left to right. 2 black eyes, cut over his right eye, cut over his nose. This was a cover-up that John was murdered inside that house. His body was placed outside.
But in a statement to ABC News, the prosecution says there was no conspiracy or cover-up. Such claims have been systematically refuted by evidence submitted to Norfolk Superior Court. The prosecution also said that, according to O'Keefe's cell phone GPS records and 11 witness statements, O'Keefe never entered Albert's home, and that a medical examiner found no signs of Mr. O'Keefe being involved in any type of physical altercation or fight.
There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds.
ABC News reached out to attorneys for Brian Albert and Jennifer McCabe, but did not hear back by the time of this broadcast. In a previous statement to the Boston Herald, McCabe's attorney said the whole scenario is baseless. Reed is scheduled to appear next in court again in September.
Hi, everyone. George Stephanopoulos here. Thanks for checking out.
All right. Well, that's the end of that. So what do you guys think? Let me know in the comments below. I know media has been portraying all sorts of things about this case, and I find that it doesn't help to listen to them. It helps to listen to the people who actually are in the know about the case, and especially certain YouTube creators, people who, you know, are dedicated to finding the truth in these cases when our own investigators don't want to find the truth of what happened. That's the thing. Like, John's gone, and everyone's saying that, you know, we're all here distracting from the fact that it's about John, but we're not, because justice for Karen is justice for John. John wouldn't want the wrong person going to prison for him. He wouldn't want his girlfriend going to prison for him when it was actually Brian Albert, Colin Albert, and whoever else, Jen McCabe, all the other people that are complicit in hiding it and framing her. So all of those individuals need to be behind bars, and that's what he would want also. Especially, you know, being the good cop that he was. He would want the bad cops put away. I guarantee it. All right, so on that note, I am going to let you guys go. Thank you so much for watching. Please be sure to like, comment, subscribe, and I will see you in the next one. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.